on the Bull SHIT featuring SB and Dolly. Leave your HOE lonely, go catch a homicide, show me if you're down to ride. Want to know if you slime or not. I'm back on the BS, riding around with a full clip, FN with the blue tip.
And we are back, and we're back. Go ahead and hit that like button, y'all. It helps us out and it helps you because it helps us keep bringing you this content. Now, what we're going to see in this video today, y'all, Judge Whitaker is going to apologize for having used the N-word. Yes, she read off some social media postings and one of them had the N-word in it, and Judge Whitaker just let that bomb drop. Well, you can see that in our previous video. You're going to see her apologize in this video, and then you're going to see them get into some lyrics. Y'all, as you can see from the coming up, they're going to talk about a lot of lyrics. So if you're interested in whether or not lyrics should be able to be used in a court case, watch this whole thing because that's what they're going to be talking about today. It's really interesting stuff. Other than that, y'all, if you're interested in becoming a paralegal, working with lawyers, helping to fight the injustice, go to careerparalegal.com and we'll get in touch with you. We've been helping people get into the legal field for over 20 years. Yes, this is a real course. Yes, we really do this. Yes, we're good at it. Go to careerparalegal.com. And with that, not going to make y'all wait any longer. Don't forget to comment, like, subscribe. Do like. Please hit the like. Let's get into it.
Before we broke for lunch, we were hashing through a bunch of Instagram conversations, and I was reading one out loud and basically saying it as my eyes were going over it for the first time ever, and just reading whatever was on the paper, and I read out the word niggas, which I hope that was not offensive to anyone. It was certainly not meant to be offensive to anyone. I do not use that word, and it was merely I should have been looking first before I said it, whatever I said out loud, to edit if there were, any offensive words. So I want to apologize on the record for that. Now, with regard to the songs, well, thank you. I appreciate that. I did not mean any. I was not able to listen to the songs because nobody sent me the songs we might be litigating. I think it was 1:35, and I'm still waiting for it to come over the ether, wherever it goes, before it gets from one email to another, of what the songs are and what the objections might be. And if y'all were working on it the whole lunch and that's why it didn't get to me until now, that's fine. But we'll just have to listen to them in court, which is fine, and y'all can tell me the objections now.
The state has indicated that there's 4 songs that they're seeking to admit. Some of the songs have multiple artists on the song.
Okay.
It is my understanding that the state is not intending to introduce the words of any of the other artists on any of the songs. Is that correct? I mean, if
Yes.
Okay.
That's what.
I am.
Except one, which would be what we talked about with the chorus, which is red light.
Okay.
There's only one that we intend to introduce the words of someone else, and that would be the song Red Light. There's a portion before we believe is Mr. Stillwell's voice rapping on the song, which would be the chorus of the song that we would intend to introduce.
And I think that was B Slime, correct?
Yes.
Okay. So, Your Honor, with those 4 songs, I'm not in a cooperative mood with the state at this moment in regards to this music. So we are objecting to all of it. Our objection to anyone that's not saying the words of anyone other than Mr. Stillwell it's the words of someone other than Mr. Stillwell. The objections for the lyrics that are alleged to have been rapped by Mr. Stillwell are that 404A, bad character. Of course, all this is also under my client's First Amendment rights and his artistic license.
Certainly, as I think has been litigated before, and as I think I have noted before, everybody has got a right to say pretty much whatever they please, as long as it is within First Amendment realm. But if what you say can then be argued as evidence against you,
Right.
It's not a First Amendment violation for a prosecutor to say, hey, you said this at this point, and we think it's evidence of whatever this crime is. So.
Understood. So I felt the need to include the First Amendment in that, but really, as far as the Georgia rules of evidence that are applicable in this case, it's going to be 404A and 403.
403 being, I mean, there are a lot of...
Unfair prejudice.
Okay.
Our stance is that there's talk about homicides, ops, guns, and all the rest. And our stance is just generic talk about guns and crimes and all of those things are not meant to be admitted in a criminal trial unless there's a nexus to the crime at hand or the crime that's being litigated. So that's where would the 404A and the 403 unfair prejudice would come in. So I will say, Mr. Kokomo, if this assists the court, Mr. Kokomo did some sort of AI work to get the lyrics on paper.
Wow.
So we appreciate him for that, but that might help in the analysis of this.
And the 4 songs at issue are, just somebody read them to me, Lizard Walk, Red Light, what were the others?
BS.
Okay.
And Ran This Money.
Okay.
And so, Mr. Kokomo, if you would, and those, I'm not saying that those transcripts are 100%,
Exactly accurate,
but it
yeah.
gives, because some of these, the cadence of the song is relatively quick. As well, Your Honor, the other issue that I have, and it's more of a question than an argument at this point, these were seized off my client's phone, and we've already litigated my client's phone. And
The
that was
seizure itself,
yeah,
yeah.
the seizure and the search of the phone.
Right.
However, in my reading of the phone, it indicates a creation date. I think when they extract the phones or the information from the phone, it gives a creation date of all the data as if it's created on the date of the extraction, because it's all the songs, all the audio files are showing a creation date of 3/17/2022, I believe. And I don't imagine that Mr. Stillwell on the early morning of 3/17/22 was in the studio actively creating, 12 songs that are, or however many are on his phone. My question is, if the state knows or has an opinion about the date of the lyrics at all, because I'm just getting that from the readout from the
I thought he actually
extraction.
was in the studio during the early morning hours.
He was,
of one of those days.
but just from my very limited knowledge of what it takes to create a song, 12 songs wouldn't have been created in one studio.
I would imagine,
Right.
does that just mean that's the date and time in which he uploaded them to his phone?
Yes, Your Honor. It appears, and Mr. Atkins is looking it up and pulling it up. Some of the songs we agree were made pre-2022, somewhere in 2021. That's when some of the songs were created. We're
Okay, do
pulling
you
up
know
which-
whether the created date, what it means? Does it even mean this is the date it was uploaded to the phone, or?
That's what we're trying to get clarity of. We
Okay.
do believe, just because we know the date that some of these songs were posted either on another phone, that we know that he did not make the songs on
Right.
3/17/2022.
So does that date does it matter at all for anybody? I mean, do we even need to show that date?
I don't know as far as, well, I think it does matter if the state is going to be arguing that references are made to an event and that event hadn't happened yet. Of course, that would make the creation date important. And I'm not saying...
So anything that happened after that date, is that what you're saying?
I'm saying if there's references to, if the state's saying there's a reference to something and it turns out that the song was made before the actual incident.
Well, Your Honor, let's be clear. There's 2 murder cases in this.
Well, there are 3.
Well, 3, but 2 involving Mr. Stillwell.
Yes.
So the date itself, we don't necessarily need the March 17th. We do need to know it was on his phone, and it was on his phone when we captured his phone, which was on March 17th.
Okay.
Well,
neither of the murders that are in the indictment that Mr. Stillwell is charged with happened after 3/17/22,
No.
did they?
Right, but what I'm saying is if the state has information from the data extraction, all I'm seeing is 3/17. If they have information further information that indicates a date of creation beyond that, I would like to know that because I think that's relevant. If they don't, then they
And
don't.
you're meaning date of creation is when the song was recorded in any manner,
Right.
not when it was put on his phone.
Correct.
And we'll provide it. Like I said, there
Okay.
are a few that we know
All right.
were.
But is it
This
fair
is in
to say that
2021.
we think that created on that date from this phone dump means the date it was uploaded or added to his phone as an audio file?
I don't want to say that for sure.
We
but
don't even know.
Yes,
Okay.
yeah.
All right, so moving to the lyrics, and y'all are saying that on Red Light, there's someone else who is also singing whose words you think are relevant. Is that right?
Yes, Your Honor. B. Slime, who we believe is a YSL
Okay.
co-conspirator, says the chorus in Red Light, and that chorus comes right before Mr. Stillwell's verse.
Okay.
The chorus, I believes approximately at 144.
All right. So the chorus and then a verse by Mr. Stillwell. And that's it in terms of anybody other than Mr. Stillwell singing or rapping on any of these 4 songs?
Yes.
Okay. All right. Do y'all have the sheet of the lyrics or, an approximation of the lyrics? Okay. And so the objection on the B Slime chorus that comes before Mr. Stillwell's verse is what?
It's not his words.
Yes.
And there's references to Red Light, which is could be viewed as let's just say the Schmo Drinks homicide occurred at Red Light. So, and that's really why I'm interested in this song in particular about the information that the state has. Of course, I have access to my client, but if my client chooses not to testify, then that information wouldn't come out through him. So what I'm wondering is, do the forensic examiners that look at the audio file have any opinion about the creation of that audio file?
I'm not following you now.
Okay, so my understanding of how this works, you're at the music studio. There's an engineer working there with
Right.
you. You're creating music. At the end of the session, you are sent the audio file by the engineer.
Okay.
Okay, and that's how it would end up in your phone or something,
Okay.
or your computer, whatever device you have.
Okay.
But we just have a 3/17 date. Of course, I'm not providing live testimony of this fact, but I know that song wasn't created on 3/17. And if
Well,
we,
it has to have been created sometime before.
Right. And
Either before or on 3/17. And you would like to know, was it created in like January of 2022?
well, if the state's going to argue that the words red light are a reference to the Shamal Drinks case, then by definition, it would have to have been created after the Shamal Drinks homicide. And I don't believe that to be true. And I'm just wondering if the state has any proof that it was created before.
Or if they're even going to argue that.
Right.
I don't know. Are y'all arguing that red light refers to the Drinks death?
No, our argument is going to be that with the nature of this criminal enterprise, that they don't mind killing their ops at red lights, generally speaking. I mean, so the fact that Mr. Drinks was murdered at a red light is consistent with the nature of the enterprise, Your Honor, that how significant is it that there's a song in which they talk about shooting their ops at red lights?
All right, well, then I would say that pretty much is an argument, even if you just say 2 + 2 instead of 2 + 2 = 4, you're saying this is a reference to the Drinks killing. So, which you're certainly entitled to do.
Right. I mean, we can't say specifically. We don't know if, we don't think, and we're confirming the time that he went to the studio immediately after and wrote this song. I don't think that occurred. But there is an inference that this idea of killing your ops at the red light is relevant, given that Mr. Drinks was killed at a red light.
Well, and that's where kind of the 404A and propensity and everything else comes in, because Your Honor wasn't here at this. Maybe you were. When I think you may have been. Kenneth Copeland was on the stand.
Oh yeah, I was there for some of them.
You remember? And I asked him, and red lights are kind of a recurring theme. And I asked him about masks and tint and red lights, and he said, "Oh no, that's a must. Tint is a must. I don't stop at red lights.
Right,
that's a must."
That.
So these are generic themes throughout this type of music, and that's.
Yeah.
I think it's kind of trap and drill, and there's just a lot of references to ops. These are common themes in this type of music. And so if the state can't show that it was created after the Drinks murder, which I don't believe they can show that, then it's just kind of a general statement about red lights and the circumstances in which we live. And to me, we're going into propensity and 404A.
I don't even know what the words say, so
Okay.
I can't really say whether it's propensity evidence or not.
And the red light portion, I'll just reiterate, is not Shannon's words either. It's B. Slime doing the chorus.
So at some point, am I going to get the words, or should I just open up the songs and listen to them?
I think it's somewhere in between their computers. You sure you said the right address?
And with regard to the rest of it, is the objection, well, and I know Mr. Kendrick has objection too on, I believe you said in the email, it said 503, but I assume you meant 403.
I was typing quickly, Your Honor. I apologize.
That's fine.
I was really typing on behalf of Mr. Sharp there.
Okay.
I may have some.
Okay, so 403 and 404A. So same objections then. Okay. Which I can't rule on until I know what the words are. And here they are.
Okay.
Thank you. Okay, so we'll start with the first song, BS. Well, the highlighted portion Kay went and clocked them Stepper's twin?
I think it's something that, yeah, I may have done, I don't know. I didn't highlight that. There's no significance to that. That's just
Okay, so just look at the whole entirety of it. Is Dolly on singing on this or rapping on this or something?
She raps on a verse.
Am I supposed to ignore that verse? All right, I'm going to overrule the objections on the BS song. Moving on to Lizard Walk. And if there's something in particular you want to point out that you think is an actual 404A violation,
Do you want,
let me know.
this is,
But when you choose to sing about it,
no. I understand that way of looking at it, Your Honor. Can I go back just to fully articulate on the,
Yes.
and I understand you made a ruling, okay? So on the Bowl SHIT featuring SB and Dolly, leave your HOE lonely, go catch a homicide, show me if you're down to ride. Want to know if you slime or not. I'm back on the BS, riding around with a full clip, FN with the blue tip. I ain't no mediator, I'm the worst to face you. It's time to ride out, ain't no hiding out, FN destroying walls. I seen an op fall, FN divide y'all. Shell, that was my call, okay. So, my argument is that, for instance, these two homicides that my client is charged with, there's no indication that any of those lyrics reference specific evidence or specific facts regarding those homicides. Certainly they're homicides, and he's saying in the song, go catch a homicide. Show me if you're down to ride. And my argument is, do I love the words in this song? Do I think other people should? Not really, but that's not really the point. The point is, in my mind, does this song and the lyrics make specific reference to crimes that are charged beyond the general, oh, commit crimes, I commit crimes, I'm tough, I'm bad, I'm not scared, I carry a gun, I ride. And the way I view the lyrics in this song, again, if Mr. Stillwell asked me, is that a good idea? No. But does it make specific reference to known facts to say, that would allow us to say, oh, he's talking about the murder of Donovan Thomas or the murder of Shamal Drinks versus just generally talking about violence. I'm a tough guy. That's my persona in the music. I do this type of music, and I'm going to rap about homicide and killing and guns and crime. My stance is that the lyrics of this song, now Shell was my call. That was my call. I can acknowledge that the state would likely argue that, oh, there's someone on the other side that goes by Shell. Okay, that's a specific reference. But again, there's nothing in this indictment that has anything to do with Shell Kell being shot, killed, or anything else. So that really, I guess it shows a dislike for Shell Kell, apparently, which I think at this point, that would be cumulative, because I think it's pretty clear. There is a dislike. But I don't think there's enough in this to say that it's a specific reference to the crimes that are charged as opposed to just general bad acts. And that's why I'm labeling it as 404A.
All right. Well, there aren't actual acts necessarily in here.
What do you mean? Your Honor, like, I'm sorry.
These are lyrics.
Right, but the lyrics that would reference the any specific crimes that he's charged with, as opposed to generalized criminality, generalized violence, and that's my concern. The way I understand the analysis is, yes, if there's specific references, that's one thing, but just because you're a rapper that raps about guns and drugs doesn't mean if you're charged with a crime or violence, drugs, guns, and violence, doesn't mean if you're charged with a crime, we just bring in all your lyrics about drugs, guns, and violence. So my argument, I hope I'm articulating well, is that these lyrics are just generalized, boastful, bravado, criminality, sells.
Yeah, it's a style of rap music, including some of the topics that are commonly found in rap music. It's not evidence of bad character such that it should be kept out because it's being offered for propensity reasons.
Okay. Well, I would also argue that under 403, there's confusion of the issues as well. Because, again, we're just talking about, unless there's a specific nexus to a crime, we're just talking about generalized crime, and that could confuse the issues for the jury as well.
Okay, I understand your argument. Overruled. So, Lizard Walk. Anything specific in this that you want to point out to me that you believe to be, either 404A or 403 specifically? Having, and I'll assume that you want to adopt the general arguments for each of the four songs.
Right. Well, I mean, the song is just full of bad character evidence. Dodging all your shots, send them all to my ops. Let that bitch rain out the drop top. And
Dodging your shots is not bad character evidence. Saying, man, I'd rather that go to the ops is not bad character evidence. I don't know what rain on the top of the drop means, but. Okay.
so this is my concern, Your Honor, is that jury hears these lyrics.
Get any? Okay. I don't know that we're going to need 4 of these songs. So I may need to turn to the state and ask why there's anything significant in one of these songs that's not covered in another that y'all want to show or feel is relevant.
Yes, Your Honor. So when you look at Lizard Walk and even the verse we just said, let that bitch rain out the top of the drop, Your Honor, it's the state's belief that when Donovan Thomas was murdered, that there was an individual shooting out of the rooftop of that vehicle as they drove down McDaniel Street. And so, as a party opponent admission, which this is for an individual who was alleged to have committed that crime, to rap about letting it rain out of the top of the drop, we believe is relevant information, Your Honor.
All right.
Additionally, Your Honor, at some point towards the end of the song, he says, YSL through the roof. It is a light show when I bring little tick out. It is a light show when I bring them sticks out. It's a light show when I bring them blues out. It's a light show when I bring Moontunk out. And we believe that there has been evidence presented that at one point, Moontunk was an alleged shooter of YSL. And then it kind of graduated to other members, one of those being Mr. Stillwell. So those things we believe would be relevant with the specific song, Lizard Walk.
Mm-hmm. Anything further, Mr. Short, you want to be heard on?
I think the references to to the extent that the state's arguing for admission by references to Moontunk and Tick, I think that those relationships have been well established without the need for this song.
All right, well, it sounds to me like it goes beyond just that. So I'm going to overrule, let that in over objection. So moving on to red light. Any specific argument on this one?
You're asking me? Well, the red light part is not uttered by Mr. Stillwell. That would be B. Slime. I will also point out that from my recollection, understanding, and notes, at the bottom where it says SB, indicating my client's verse, says where, and I don't know if this is correct, it says Hilton House on God. And then at that point, it goes into a chorus that's sung by someone else as well.
The I Be With Killers?
Yes. So my client's words are basically beginning on when I come through and then ending on God. Oh, Heavenly House. Okay. Heavenly. So.
All right, so does the state want the last chorus, I guess? I Be With Killers. I don't know if that's chorus or a verse, but.
You're right, that's just repeating the same chorus that comes at 144, so we don't need.
All right, so y'all don't need that part anyway.
But it sounds like the state is still intending to introduce
The first part.
the chorus, or B. Slime's chorus, where red light is repeated and repeated and repeated.
Yes, Your Honor.
We
could say that's an adoptive admission too.
I don't know if it's an adoptive admission or not, but he's singing on the song with who is in this person singing that other verse is what? Who?
B. Slime, that we believe is a YSL co-conspirator as well, Your Honor.
And it may be the chorus, may be that other person, Vito. It's not Mr. Stillwell, though.
All right, so there's obviously the chorus starts I Be With Killers and ends with the red light, right? And so that opens the song, and then there's the I Can Make It Rain on Birthday all the way through. If I had a problem in the streets, I'd never run.
Right, so we don't want that. That's not.
Okay, so.
We're asking, they repeat the chorus again.
Okay,
And
so
then-
what y'all want is what is essentially the second time the chorus is sung, and then Mr. Stillwell's verse that he sings. Is
Yes.
that right?
Yes, Your Honor.
Okay, I'm going to rule that what Mr. Stillwell sings can come in, or raps can come in.
Okay, and I understand the court's ruling. Just for the record, I would just like to object under 404A and 403. There's talk about I see an op, I'm taking them down, gun them down, walk them down from a mile, walk them down. The last homicide, I smiled. I don't believe that those are specific references that include specific facts that could be linked and provide that nexus to either the charged homicides for Mr. Stillwell. Obviously, you can tell from me arguing it in my prior statements, I would very much prefer that these not be in evidence because in my mind, they are very bad character evidence. And so I object under 404A and 403.
All right, I don't find them to fall under 404A at all, and I'm overruling both objections.
And the last song that the state identified, Your Honor, we did not have the opportunity to do the AI.
Okay, all right.
So that one we might have to listen to.
Okay, that's fine. I may or may not be able to discern what the words are.
Which one you on?
that, I guess, ran this money? And it's just the Mr. Stillwell part, not the Rooney Lee part?
Yes, Your Honor, it'll start at approximately 1:45 to the song.
All right, if y'all will just play that for me.
By my client, or can be considered, ruled upon by the court that it's an 801c3 statement, I would have objections to anything else coming in to trial at this point. Obviously, there could be some exceptions, but if I'm looking at the first one, and it's just like, again, there's no context. I'm not trying to be difficult, but it's like inboxing me, asking paperwork on Jermaine Little, A.D. Higgins, picking me out from the lineup. I don't even know what this is. And then Shell is having a conversation with Bay Boy. I just don't know what this has to do with anything. And if it does, then I'm all ears, but.
So, Your Honor, just generally, the items in the March 22 folder are items between either YFN gang members or YSL members in the weeks beginning between March 3rd, 2022, up until about March 17th, 2022. Mm-hmm. So this entire folder is screenshots of Instagram conversations that were occurring in the midst of what was brewing to be the ongoing war, especially after Mr. Bennett had been stabbed in the jail. So Mr. Bennett's stabbing in the jail triggered this iteration of the war that we believe.
And remind me when the date of that jail stabbing.
So that was on February 9th, 2022. And then the media, there was a bond motion filed, and on March 3rd, 2022, an emergency bond motion for Mr. Bennett. And that was publicized around that same time. And so it was immediately following the publication.
Okay, and so is there any cross-communication between the two groups? Or is this going to be YSL communications and whatever the other gang is
The
communications?
majority of the things in this folder are going to be posts that further the gang's violent reputation. It's going to be antagonizing the rival gang through these use of these posts, as well as kind of which were used to like flaunt and fuel the gang work that we kind of.
All right, well, it's an awful lot of them. So can y'all narrow it down to what you feel like would show what you're seeking to show?
Yes, Your Honor.
Without, okay.
And can I just use this first one to just illustrate my concerns, Your Honor? It's just like, it says image 0609. I can't see, I have no idea other than I think I probably know Michelle coming up like this. I have no idea who is speaking. I have no idea.
Maybe that'll be when they don't end up wanting.
Right, but this is just my general concern, just about it being true. I don't know how this would be admitted to evidence. We don't know a date.
Yeah, I don't see a date.
So Your Honor, there are.
I don't want to litigate things we're not going to ultimately need to litigate. So y'all go and, because you haven't already figured out what you actually need instead of dumping all of it. Figure out what you actually need, provide that to the defense, and at some other point, which might be Monday, we'll litigate the admissibility of it. So that's this March folder. Is there anything other than March 2022 folder in this folder number 90 that we still need to reach?
No.
Okay.
That's
So-
good. And 94 is shorter.
Okay, so,
I have questions on 94.
all right, so we need to come back to that. We need to come back to the folder 171 that had to do with Eppinger and Sumlin we need to come back to the, I deleted Instagram portion from this morning. We are, at this point, going to move on to folder number 94 and see what it is within that.
Ms. Hilton, I have a question about folder 94.
Yes, sir.
The first folder is labeled, it's got some numbers, Diamante Kendrick, and it's a phone dump. But I don't know what portions, I mean, obviously there's an entire phone in there. What portions do y'all plan on using?
Your Honor, Mr.
You can call me that if you want to.
Mr. Weinstein, I'm sorry. At this time, we don't intend to use your client's phone.
Okay, thank you.
If the change will brought, but at this time, we don't plan on.
I understand. Thank you. If it does change, can you notify me as soon as possible?
Yeah, because there are only supposed to be a couple of more weeks at most left to y'all's evidence. So if you're telling him right now we're not going to use it, you better change your mind really quickly if you then decide we are going to use it.
Yes.
Monday at 6 p.m.
Fine.
Yeah, and if you do notify me, if you would just please provide me specifics of that portion which you do choose to use, that would be helpful. Thank you. Thank you.
Can I share a text that we forgot to go over from the iPhone 13 to Mr. Stillwell? It was included in the large compiling that we sent with Mr. Jackson's former paramour. But this is where he is sending her a text the day that Lucci's staff saying they just wet Lucci's up, and that was before it became public. So it just didn't further. So the gang and how they're all included in the knowledge of, and we believe that's highly relevant to the charges and the acts in this indictment.
Are you going to make an objection?
It is my client's statement per the state seal. Mr. Weinstein might have an objection on behalf of his client.
Which portion?
We can include the limiting instructions, but it's not to.
Because I don't believe, well, I'll let Mr. Weinstein argue that it's not a statement by a co-conspirator furtherance. I believe my client is communicating with Ms. Alexander.
We'll make a motion on behalf of Mr. Weinstein.
No.
That should be included.
Yeah, we would need that for sure. I'm sorry, I was consulting with my client on something else at the moment.
It was my fault. I tried to know it.
Okay, so nobody has objection to this?
Well,
Okay.
I think
but I would need a limiting instruction, Your Honor. Would you like me to draft that up?
Well, I don't know that I'm going to use your other limiting instruction, because I think it is a little too broad. But I don't understand what this is. So no, there's not, nobody's objecting. And Mr. Weinstein, you're saying you want a limiting instruction, but
I believe the issue is, Your Honor, the state is using this as a statement by party opponent, my client's statement, and I don't believe that Ms. Alexander could be labeled as a co-conspirator, and I don't believe that this would be in furtherance of a conspiracy. So I think the issue would be that it would be admissible against potentially my client for whatever the jury thinks it's worth.
so they just wet Lucci blah blah up is the phone number associated with Mr. Stillwell,
Yes, Your Honor.
saying that to his girlfriend at the time.
Yes.
Okay. All right, so it would not come in under co-conspirator exception and therefore would only be admissible against Mr. Stillwell. I'm going to use the word that makes it certain less
Thank you, Your Honor.
Okay, so what would you want that to be essentially what you sent me before?
The one that was overly broad, Your Honor?
Yeah.
Yeah, I'd love for that to be used as well.
Okay, you're going to hear about a statement made by, is it a statement?
I have no objections, just
A lyric?
specifically
This
saying what
particular
it's
piece of evidence is only admissible against Mr. Stillwell.
I don't know if I love that wording, but yes, could be considered, you know, for whatever weight you deem appropriate against Mr. Stillwell, but
Why don't y'all work on one together to give me?
Yes, Your
Come
Honor.
back to the other one. So we need, this is, what is this, do you know what exhibit number this is gonna be?
What is the number? No, Your Honor, but we'll know by, Monday.
Okay, I just wanna,
It'll be a part of.
y'all make sure that somebody.
We'll
if
coordinate.
not everybody, remind me before it comes in that I need to give whatever the limiting instruction is gonna be. All right, what's next?
so in 94, there is a folder labeled Ryan
Actually,
Stillwell.
can I stop you for just a second? Because I'm trying to figure out a court order for Tuesday, and
Could
I have my mind on too many different things.
could we maybe take a recess?
Let's take a break. And by the time y'all get back, I will have gotten that off my plate, hopefully.
And I will sit with
Right.
these fine people and see if we can talk through
Thanks,
something.
appreciate it. Okay.
The state intends to give the pared down version of the March 2022 folder over the weekend. And then we'll be able to discuss if there's any objections to it and then be prepared to argue it on Tuesday.
Write myself notes. Okay, and y'all, the defense will come up with a proposed instruction for the text from Mr. Stillwell to his girlfriend about drinks being dead.
Lucci, Your Honor.
Lucci, whatever, sorry.
No, it's okay. Thank you.
My bad, Lucci.
We'll take care of that, Your Honor.
Okay. The one before that was the song lyrics from Mr. Stillwell. First of all, so your proposed is the general, sometimes evidence is admitted against some parties and not others. When this happens, the evidence may be considered by you, the jury, only as to the party against whom it is offered and not against any other defendant or for any other purpose. That's fine. That's just kind of the general law. During the testimony of the next witness, you're going to hear about statements. I definitely do not want to call them statements. So maybe lyrics, what? Sung, rapped, by, just lyrics by.
Lyrics uttered, spoken, rapped.
Words spoken with a beat.
I would rather not words spoken with a beat. Lyrics.
Song lyrics of defendant Stillwell, by defendant Stillwell.
The state that the state asserts is defendant Stillwell. I don't know if we should instruct them that it is definitively. I'll say that I am not, as part of my defense, going to be claiming it's not, but out of abundance of caution, maybe.
Okay, how about just certain song lyrics? You are to consider those lyrics Did you copy, yeah, Mr. Short on this also? You did. Okay. Can y'all work on this one as well, please?
Yes, Your Honor.
And then I am not sure that the reason I said it's maybe overbroad is that you're saying that those can't be considered in any way in determining the guilt or innocence of Mr. Kendrick with respect to any charges.
You'd like to leave the RICO count out
I
of that?
just don't think that that's legally accurate. Yeah.
Okay.
So.
We'll try to more narrowly tailor that, Your Honor.
Okay. Thank you. And I know we had talked previously, we thought we were getting to the Ryan conviction first, so I talked specifically about the language for when Mr. Ryan's conviction came in, but now that conviction won't come in, but we still have the possibility of a guilty plea conviction for Mr. Kendrick being admitted, right? Yes, ma'am. Okay, so I think I shared with y'all that language. It was kind of Kendrick on the top and a version of it on the bottom for Ryan. But anyway, I will if I haven't yet. But I would think it would be, and I don't know whether I could either say a guilty plea conviction of Mr. Kendrick or a guilty plea conviction of Mr. Kendrick for whatever it was for, will be admitted for your consideration and may be considered by you only against Mr. Kendrick and only as to counts 1 and 63, which is the possession of a firearm by a convicted felon. You may not use this conviction in your consideration or deliberations against any other defendant in this case. Now that we only have one, I could say that, or I could just say against Mr. Stillwell. Any other defendant in this case. Okay. It is not evidence of anything against the other defendant. Each defendant has a right to have his guilt or innocence determined solely on the basis of the evidence presented against him, not by what may have happened with regard to a criminal prosecution of someone else. I'm going to have to look back at, what is the conviction for? What is the guilty plea conviction for?
It's possession. No, it's 15 SC, we'll pull up 14011.
No. Your Honor, what I was going to do before I left today, if I had the opportunity, I was going to go through and
That'd be great.
all those for Mr. Winfrey, for my client.
That'd be great.
For Mr. Kendrick and Mr. Nichols.
Let me ask this. Is it an overt act? Whatever he pled guilty to.
They are overt acts, and that's essentially the problem is their admissions. I mean, at this point, I would argue that Mr. Nichols' guilty plea should really not be in evidence because it doesn't have any probative value to anyone else's case that's sitting here at this point. And same with Mr. Winfrey for that. And
If they're overt acts, though, and they're alleged to be in furtherance of the RICO conspiracy, then you are right. The convictions themselves are not. But what I'm trying to figure out, and if like, for instance, Mr. Kendrick's, whatever he pled guilty to, is also an overt act, could y'all?
It is, it's for the October 1st, 2015 incident.
Which overt act?
It is over at number.
Was it 58 or 59?
58. Well, no, 58 is the gun charge.
58's the gun. 59 is the criminal street gang activity.
Overt act or count?
Over at.
Overt act.
Okay. Overt Act 58?
56, well, all 56 to 59 is the same incident, so it would be really over.
What did he plead guilty to? 56 through 59?
Yeah.
Okay, I think I'll just pull up his guilty plea.
He pled guilty to the entire indictment, which was the conspiracy to commit murder, theft, possession of a firearm, and participation in criminal street gang activity.
And did that participation in criminal street gang activity, was that specific? I don't think he did.
I don't think that's accurate. Can
I
I
don't think
take a
so
look
either.
at that?
I don't think he pled guilty to the gang count at all.
Yes, he pled guilty to conspiracy to commit a crime, participation in criminal street
To
gang.
commit a crime or to commit murder?
The indictments.
We've got, I mean, thank you. We actually have, I'm sure, somewhere the guilty plea. I'll make sure that it is not something you didn't plead guilty to. So many folders in this case. Conspiracy to commit a crime, 1648.
Aggravated assault. Conspiracy to commit a crime, which was aggravated assault. That's what's represented in count 1 of that indictment. Participation in criminal street gang activity. Possession of a firearm or knife and commission of a felony. Theft by receiving stolen property. And BGCSA. So there's 2 counts of BGCSA, another fleeing and attempting to elude while driving. But guilty to the entire indictment. All 11 counts.
Okay, y'all have it listed. Y'all have I'm sorry, not count, but Overt Act 56 as him having committed the offense of conspiracy to commit murder, which I realize that maybe y'all could arguably prove that, but that's certainly not what he pled guilty to. So, death by receiving, possession of a firearm. Where's the gang count? Okay, and the gang count that he pled to, I just wanted to see if it specified which gang, and it does not. So, and your 59 is specifically YSL, but that's not what he pled guilty to either. Okay, but anyway, so there's obviously evidence that came in aside from his guilty plea, which hasn't come in yet, but presumably will come in. And given that it's alleged to be an act in furtherance of the RICO conspiracy, the conviction can't come in against anybody other than Mr. Kendrick. But I was going to, and I hadn't sorted it yet for Mr. Kendrick, but I know for Mr. Ryan, you know, y'all were presenting evidence of the murder. And you have presented some evidence aside from the guilty plea to this attempted, whatever, conspiracy to commit aggravated assault and or murder. And so I was going to say something like, to the extent the state offers evidence aside from Mr. Kendrick's guilty plea conviction to attempt to establish count 1, any other such evidence aside from Mr. Kendrick's guilty plea may be considered against each defendant, because that's true. Again, as to count 1. Yeah. Okay. So I'll be happy to make some adjustments so that this reads like what I just said and send that out to y'all for any comment or correction or improvement that y'all might want to suggest. And then I think that'll get us to the end of what we need to do today on the record, and then y'all are certainly welcome to stay. We're not at 5 o'clock yet. We're just almost to 4 o'clock to find the evidence and then to organize the evidence, agree upon the exhibits that have already been admitted, whatever you might want to do. That's ultimately going to need to be done at some point.
And I was going to request from the court, from counsel, if I took the evidence from this room over the weekend, or
I don't think we can do that. That has to stay, whatever's been admitted has to stay with the court reporter. Right?
Well, we're holding some of the
Oh, well, right, like guns and drugs and things, y'all still have possession of. Okay, so, I mean, I don't mind if everybody wants to come to agreement, I don't mind. Are you talking about just to take it home and organize it? I'd really rather y'all look at it together.
Yeah, and I don't have, I think it's probably unwise, and it's nothing personal against Mr. Abate, of course, but I was just being selfishly thinking about closing, and we need to figure out where different things are. And then, of course,
I would highly recommend that y'all stick around and try to get the evidence that's been admitted already organized together.
okay.
And I know that,
Can we take it to the jury room to just? Oh, that's right, because they got their stuff in there right now. Can we take it to that side room, just so we can have something to spread it out on?
as long as Ms. Weaver ends up with custody of it again when y'all finish, and as long as y'all are all together with it. And I don't mistrust anybody. It's just not a good practice to. Yes, you can also do it here in the courtroom. And then this is just a lawyer exercise anyway, right? So we're done for the day. Y'all don't need me. You don't need your clients. Is this just y'all getting organized? Okay.
Your Honor, may I just put one brief thing where I talked with defense counsel for the ankle monitor company.
Oh, thank you, Mr. Atkins.
You're welcome, Mr. Sharp.
Yes, what's the next?
No, Your Honor, on witness number 19, which is listed as Charles Floto Ankle Monitor Company, the state was going to be using Doug Bailey for that same position as records custodian. And I talked with defense counsel about that. So I didn't want the court to be caught off guard with the name that's not on this list that's replacing this records custodian.
Okay.
So let me just put this on the record, Your Honor. My client was wearing an ankle monitor at the time of all this happening. In my view, and this has already been litigated, but I just want to put on the record, in my view, we are not disputing that Mr. Stillwell is at the BP on video, so I don't think his whereabouts to the extent that an ankle monitor clarifies anything, it's not really made any more clear by the ankle monitor. It's not really a dispute
Are
in
y'all
this
going to
case.
stipulate that he was at the BP?
Well, so the state, I believe, wants to bring out where he was through his ankle monitor. My argument was
Getting the windows tinted.
Or the car clean.
Is it going to show that? Oh, that would be interesting.
well. So I have objected on the record for
Because
the
it's going to show that
that
he was an
he's
ankle monitor.
He had an ankle monitor, and I objected under 403.
All right, but don't we know anyway that he got arrested on? Oh, wait,
I don't think
no,
he was
that
on the ankle monitor for any of these other issues.
Okay.
There was an
so-
incident in Cobb County.
Okay, what's y'all already litigated it though?
It did. We did, and I just wanted to put on the record. But I think probably if we're just going to say he had an ankle monitor on, but just leave it at that. So
Are we just going to leave it at that?
And Your Honor, just very quickly, Mr. Shard and I were just discussing, Investigator Viverito has familiarity with Mr. Stillwell, as well as others, Mr. Garlington, through her time working with the probation department, Mr. Copeland, and just figuring out how to deal with how she knew them. We're going to probably use some language such that she worked for court services, and that's how she knew them, because he doesn't want us to mention probation. But we just wanted to bring that to the court's attention.
How do you feel about that, Mr. Shaw?
well, I prefer court services. I mean, I don't think that's I don't want to lie to the jury, but I think that is accurate, but not specific in a way that would prejudice my client
Okay.
or the court system.
I mean, court services sounds better than court supervision or what you just said. Whatever you said. I don't
Court
remember-
services is good.
Court- I mean, to me it does.
To me as
If
well.
y'all, whatever y'all want to agree to, but
That's fine.
all right. So y'all will stay here with the evidence and sort through it. Mr. Kendrick and Mr. Stillwell, y'all can go. We'll see y'all Tuesday. Hopefully you got some sleep over the weekend. Okay. All right. We are adjourned.